over again. Can someone please comment if I am audible now so that I can start the session? Okay, so I will start again, no problem. Okay, these are the topics which we shall be discussing today. See, I think this topic and this topic are very, very important from exam point of view because already a question has been asked from these kind of topics. Just a second. Yes. So our first topic will be the Employees Pension Scheme 2026 because Parliamentary Standing Committee has raised various issues related to amendments in this scheme. Second important article is related to sixth schedule. Third is related to maternity relief. So recently Supreme Court has given an important judgment related to maternity leave. Fourth article is about important term in news that is force majeure. So it's not important to go in very detail of this topic, but okay, so here our first topic is employees pension scheme and what is the context. So recently, a parliamentary standing committee has recommended the government that no, there must be a revision of minimum pension under this scheme because minimum pension here is 1,000 rupees and given the cost of living, the inflation, the rising cost of healthcare expenditure, so 1,000 rupees is very, very less for any person to survive. So, Parliamentary Standing Committee has recommended this. Now, let's go through about the summary which is given in the article. So, this already we already discussed that committee is recommending that this minimum pension must increase from 1,000 and what the pensioners are demanding. So, they need pension of around 7,500 per month. Then only they can balance their cost of living and other expenses. Now, about the EPS, that is Employee Pension Scheme. So, who implements or who administer this scheme? It is implemented by the Employees Provident Fund Organization. And EPFO comes under which ministry? So it is Ministry of Labor and Employment. Now, this government contribution and all we shall be discussing in detail. So please leave it. So basically, the committee suggested that there must be increase in pension to a realistic level given the inflation and cost of living, and there must be budgetary support also for this scheme. Now let's discuss what all things are important from exam point of view. So first of all about the Employees Pension Scheme 1995. See, a new scheme also came in 2026, but first of all you must know the original provisions. What were the provisions in 1995? So introduced in this year and who implements it? EPFO, that is Employee Provident Fund Organization under Ministry of Labor. So what is the main aim? See, aim is to provide the pension benefits, obviously, but here the catch is the organized sector. So this scheme provides pension benefits to employees who are in organized sector. That means it does not have universal coverage. So please remember because UPSC confused with the statement that pension benefits under EPS scheme is provides the universal coverage. So that statement will be wrong. And second aim is to provide financial security for employees post retirement. Now, let's understand what is the percentage of contribution, who contributes, so how your pension fund and provident fund is created. See, let's start from here. So, first of all, you are the employee, and then we have employer, and then we have government. So, for example, you are employee. So, from your salary, 12% of salary will go in EPF, that is Employee Provident Fund contribution. Now, employer will also contribute 12%, but out of this 12%, 8.33% will go to employees pension scheme. So, this is Provident Fund and this is pension. 8.33% will go here, and the rest of the amount will go to EPF. Now, to this 8.33% which goes to EPS, in this government also adds 1.16%. So overall, we can say that employer and government together fund your pension. Okay, so 8.33% of employer and 1.16% of central government, this together will contribute to your pension. Now, who is eligible for the pension under this scheme? So first of all, a candidate must be member of Employee Provident Fund. That is, he must be EPF member. Secondly, his salary must be less than or equal to 15,000. So this is the eligibility. So if you are in a formal job and if you are a part of EPF, then you will get pension under this scheme. So these all things only are mentioned here about the features. So first is about the employer and employee contribution. So we already discussed it will be 12%. Then 8.33% of employees contribution will go to the pension fund. And in this 1.16% will be contributed to the union government. And finally, your pension fund will be set up by this 8.33%. Now, this thing is very important. So, in this scheme, amendment came in 2014. So what happened? The Supreme Court in November 2022 upheld this order. So what was this order or what were the amendments? See, let's understand this way. So this is pre 2014 and this is post 2014. So before 2014, the pension was calculated based on the average salary of past 12 months. But after 2014, your pension will be calculated based on the salary of past 60 months. So that will be uh, 60 months, that is 5 years. So now here is an issue because generally various employees will get the salary hike or promotion in the some of the last years of working. So if you are using 12 months of average, obviously you will get higher pension. But if you are using average of 5 years, then obviously your pension will be diluted because now, for example, from 8-10 years you are getting salary like 40,000, 45,000, 50,000. In last some of the years you are getting 80,000, 85,000. So if you are using 12-month average, then obviously you will get a very high pension. But if you are using 5 years, that is 60 months of average, then obviously your pension will be diluted. So this was the difference. So pre-amendment, it was last 12 months. Post-amendment, it was last 60 months. So last 60 months thing was upheld by Supreme Court in November 2022. Now, one more important thing happened post 2014. So though people who are retiring after 2014, they had an option of higher pension to opt for higher pension option. So what is this higher pension option? See, we'll understand in this way. So, for example, so people have the option to opt, right? It's not important to no use higher pension option. For example, we have higher pension of, for example, if first a person is opting or a person is not opting for higher pension option. For example, you are not opting. So, if your salary is 50,000, then also your pension will be calculated on the minimum limit that is 15,000. Hence, your pension will be low. Now, if you are using higher pension option and your salary is 50,000, then your pension will also be calculated on 50,000 only. But no, why everything is simple? There must be a catch, right? So what is the catch? If you are opting for higher pension option, then you have to contribute more money from your EPF to EPS. That is, if you are opting for higher pension, then more money will go from Provident Fund to the pension scheme. So more money will go from PF to EPS. So in simple manner, we can say if you are opting for higher pension, then you will get lower, you will have lower PF savings, that is lower provident fund savings, plus you will have higher monthly pension. Okay, so this was the overall concept of higher pension option. But in 2026, what happened? No, this option also became obsolete. Now this option is no longer active. That's why also people are resisting. So I think eligibility was already discussed. So eligibility was income limit up to 15,000 and people must be a member of Employee Provident Fund. Now, what are the concerns? related to EPS, why people are resisting. So first, as we already discussed, this high pension option provision became obsolete and it has been removed from new pension scheme. But it was good, right? People who want to opt for higher pension. Second important thing is this criteria or this limit of 15,000 was uh, set up in 2014. So this was established in 2014, but even after 11 years, it has not been changed. So this is also major cause of concern. Third is the minimum pension, which we discussed in context. So this mere amount of 1,000 is not sufficient to fulfill all the healthcare expenses to fulfill the basic requirements. So I think this was all for this employee pension scheme. And yes, this was the PYQ which I was talking about. That UPSC asked these type of questions. So what is the first statement here? All casual workers are entitled for employee provident fund coverage. So here, for example, see this all word is used. No, so these kind are the confusing words. For example, if I ask you whether employee pension scheme 2026 provides universal coverage, so I give statement all employees are covered under employee pension scheme 2026. So whether this statement is right or wrong. So it will be wrong, right? Because income limit is 15,000. The employees who are earning up to 15,000, they are eligible. And whether it is applicable to all kind of employees, no. It is applicable just for the employees working in organized sector. So these kind of statements can be confusing in UPSC. Now, a very important article about the sixth schedule. Okay, so what is the context here? See, recently, activist Sonam Wangchuk, who is from Ladakh, he has been released and he was detained under National Security Act. Why was he detained? Because he was protesting for the demand of Ladakh for the statehood and for sixth schedule. So, before discussing the summary, let's discuss what all things happened. See, first of all, issue originated in 2019. What happened in 2019? Abrogation of Article 370. And with this abrogation, the state of Jammu and Kashmir was divided into two union territories. First was Jammu and Kashmir itself, and second was Ladakh. So here, Jammu and Kashmir have state legislature but Ladakh do not have. So because of not having state legislature, Ladakh cannot take any of its decision on its own and it is directly under the central administration. So because of that, a key demand of people in Ladakh is the inclusion under the sixth schedule of the constitution. Okay. So yes, so now people are demanding the inclusion of Ladakh under sixth schedule of the constitution, that is under Article 244. Now, what are the provisions under sixth schedule? So this schedule provides the creation of autonomous district councils, and these councils will be having a wide range of powers like power over land, forest, water, etc. etc. Now, article also says that although Ladakh has Ladakh Autonomous Hill Development Council, that in article it is mentioned as LAHDC, but they lack the constitutional protection, right? That's why they are demanding because autonomous district councils have constitutional protection under Article 244, but these kind of development councils do not have that. So this is the first important thing. Second important thing is around 90% of Ladakh population belongs to scheduled tribe. And this is a major cause of concern due to land rights, cultural identity, etc. etc. And thirdly, in 2019 itself, National Commission for Scheduled Tribes have already recommended the sixth schedule of status for Ladakh. But here the main issue is at present, sixth schedule status is applicable just for the four states, that is Assam, Meghalaya, Tripura, and Mizoram. And everywhere else where tribal population is present, they all those states does not even come under fifth schedule also. So it is not part of fifth schedule. So that's why the Ladakh is demanding all these things. But here the main issue is if you want to include Ladakh in the sixth schedule, then it requires a constitutional amendment. So this was the major cause of concern for government also. So this was the issue in brief. Now let's discuss what all things are important from exam point of view. So here. So yes, I think we discussed it. The issue arose in 2019 for because of the abrogation of Article 370, and people of Ladakh are demanding statehood as well as inclusion in sixth schedule. And about autonomous district council, it 244 have those states: Assam, Meghalaya, Tripura, and Mizoram. Now let's those states: Assam, Meghalaya, Tripura, and Mizoram. Now let's discuss the important provisions. So first of all, the provision of the sixth schedule important one is it empowers government and not the president of India. It empowers government to create ADCs and ARCs, that is autonomous regional council. So who creates governor? What he creates? Autonomous districts council and autonomous regional council. So these two can be created under the provision of sixth schedule. Please remember. Now what will be under the provision of sixth schedule? Please remember. Now, what will be the composition of ADC? So, ADC will have not more than 30 members. And it's all those 30 members are not elected, of which four are nominated by the government and rest are elected. So here four will be nominated and 26 will be elected by the government. Now, since we have discussed that sixth schedule have the provision of autonomous district council also and autonomous regional councils also. So what about regional councils? So for example, in a autonomous districts, there are various kind of scheduled tribes. Then governor can divide that area too in the various autonomous regions. So this is the concept of autonomous regional councils. Now, let's discuss what benefit Ladakh will get if it gets included under sixth schedule. This is also important, no? So, first of all, it will address the local issues like the environmental protection, like the sustainable development practices, tourism management. Because the name that was mentioned in you, that is activist Sonam Wangchuk. So, regularly, he is requesting that no people have to follow the sustainable environmental practices in the fragile region like Ladakh. So first of all, what it will do, it will address the local issues like the environmental sustainability. Second important thing is related to land rights because Ladakh, earlier Ladakh enjoyed the autonomy because it was part of Jammu and Kashmir, which enjoyed the status of special state. But now, after the abrogation of Article 350A, it was repealed in 2019. So it will address the issue of land rights also. And third, what we can say to safeguard the tradition, because as we already discussed, 90% of population belongs to scheduled tribes. So Ladakh's unique cultural heritage can be protected because of the inclusion in the sixth schedule. So third, we can talk about culture. So in this manner, you can add other kind of points also. Okay, now let's discuss briefly the difference between fifth schedule and sixth schedule. So first of all, the applicability itself. So what is the applicability? For sixth schedule, we already discussed it is the four states of Northeast India, and fifth schedule is applicable to other tribal areas in India. And at present, 10 states are there. About the administration, so for sixth schedule, we discussed about autonomous district and regional councils. For the fifth schedule administration, we have Tribes Advisory Council. So here we have TSC and here we have ADC. Now, about the administrative power. So, administrative power of autonomous districts councils are no very large about the executive, legislative, judicial, all kind of powers they have. But tribes advisory councils have the limited number of powers and they are mostly executive in nature. But for ADC, it have executive, legislative, judicial, all kind of powers. And main emphasis of the fifth schedule is on the protection of tribal rights, but for the sixth schedule, main emphasis is on the self-governance. That's why Ladakh wants the inclusion in sixth schedule and not the fifth schedule, because in sixth schedule they will get more autonomy. And yes, this is also important about the PASA Act, that is the Panchayati Raj Act. So it is not applicable in sixth schedule, but yes, it is applicable in fifth schedule. Now let's briefly discuss about the National Security Act also, because since it was mentioned in the news. So very important point is that it is a preventive detention law. That means you are preventing a person so that any other mishappening cannot occur. So you can detain a person without any formal order under National Security Act. So its purpose is to maintain public order and national security. Now these articles of constitution are very important. Article 22 and Article 22. So Article 22 says that preventive detention is allowed by the Constitution under certain reasons, and this preventive detention cannot be for more than 3 months. So these two things are mentioned under Constitution. So mention of preventive detention is under Article 22. You have to remember this. Now, what are the powers of government under National Security Act? So it empowers either central government also, state government also. So this is also important. Any government can take action. Any government can detain a person to prevent him from acting in any no prejudicial manner. Second important thing is government can also detain a person to prevent him from disrupting the public order. So all these things are there under powers of government. And what will be the period of confinement? It will be 12 months. So person can be detained for 12 months. Now here important thing is this act also provides for the establishment of body. And which body is that? It's the National Security Council. And what is the main objective of this? It advises Prime Minister on no issues matters related to national security. So this was in detail about the National Security Act. Now this article is also very important because PYQ has already previous year question has also been asked on this topic. So about the maternity leave. So here the context is the Supreme Court of India has struck down a provision which is restricting the maternity leave for the adoptive mothers. So this is the context. See, I will explain the whole issue first. So see, earlier what was the provision for adoptive mothers? Adoptive mothers could get leave only if the child is of less than 3 months. This is the provision for adoptive mothers. If the child is of age of less than 3 months, then mothers can get leave. Now, Supreme Court said that this is unfair because older adopted child also needs the care, right? So, Supreme Court removed this age restriction, and now all adoptive mothers will get leave of 12 weeks, and it is irrespective of the age of the child, because according to Supreme Court, if you are restricting the mother for the age of 3 months, then it violates Article 14, that is right to equality, and Article 21, that is right to live with dignity. And Supreme Court also suggested one important thing about the paternity leave, because according to it, paternity leave will encourage the shared parenting. So this was the whole issue, that now there is no age limit. Any adoptive mother will get the leave of 12 weeks. I think yes, we discussed all these things. So see, the all the provisions of Maternity Benefit Act to 2017, no, now they are included under Social Security for 2020. So according to this code, adoptive mothers can get leave only when the child is below age of 3 months. So code ruled that any adoptive mother will get 12 weeks of leave. I think the constitutional provisions we have discussed that it violates Article 14 and 21. And yes, all these things we have discussed. Now, briefly discuss the key benefit criteria under the Social Security Code, because since this code is new, so let's discuss the criteria. So, first of all, according to the code, if women at least to get all these benefits out of 12 months, period of 12 months, if women must have worked for at least minimum of 80 days, then only she will get all these benefits. And what is the duration? So duration of 26 weeks is for the first and second child, and of that, with up to 6 weeks allowed before the expected date of delivery. So 26 weeks is for the first and second child. 12 weeks of leave is applicable for the third child onwards, or if a woman has two or more children. So for first and second, 26, for third or after that, 12 weeks. Now, what are the provisions for adoptive or commissioning mothers? So they are entitled for 12 weeks of maternity leave from the date of child is handed over. But according to the court, it is applicable if a child is below 3 months. But now Supreme Court said that irrespective of the age of the child, all the adoptive mothers will get 12 weeks of leave. Now let's discuss some more points. So what are the applicability for to get the maternity benefit? So it covers all the establishments with 10 or more employees. So this is important. And here this code provides the option for work from home also. Code allows work from home after 26 leave period. So this is also important. Now a simple statement can be given. Work from home option is part of social security code or not. And there is provision of medical bonus also of 3,500 if no pre or postnatal care is provided by the employer. Now, in case of miscarriage, 6 weeks of paid leave will be provided. So here we discussed about first and second child, we discussed about the third child, we discussed about the adoptive and commissioning mothers, and here we discussed about the miscarriage. So miscarriage also 6 weeks of paid leave is provided. So all these things, and yes, one provision of crash facility. This crash facility provision was asked in exam also. So it is mandatory for the establishments with 50 or more employees. Now, a very small news about the force majeure. So, what is the context? So, context is related to this West Asia conflict only. So, major Gulf energy producers have invoked this clause on the oil and gas exports. So, simply for let's understand what this is. So, basically, it is a legal clause which is included in the contract. So, under this, any party can suspend its obligations without without facing any penalty. So if there is any unforeseen circumstances like the war or natural calamity, etc., so a party can suspend its obligations, the things which the party is obligated to do, it can suspend, and for that suspension no one can penalize it. So this is the concept of force majeure. So what is the aim? So aim is to provide the legal protection to the businesses, to the governments, etc., in case of any unforeseen circumstances. So aim is to provide the legal protection to businesses. It ensures that they are not sued for the breach of contract or forced to pay massive late fee. So this was the overall context. You don't need to go much in detail. Now a practice question for you. So you have to provide me answer in the comment section. Please read the question very carefully. Consider the following statements. Sixth schedule of the Constitution applies to tribal area across all states of India. Ladakh currently has autonomous district council under the sixth schedule. Extension of sixth schedule provisions to any state does not require a constitutional amendment. So please read the question carefully and give me answer in the comment section. Now, two places in news which we have you have to look. So first is Achnakmar Tiger Reserve and second is Patalkot Valley. So see the location, read prelims related points, and if you have any doubt, ask in the comment section. Now, the places in news which I gave yesterday. The first place I gave was the Natanz. So Natanz facility is located in Iran. And what is the important thing here? It is the main enrichment facility, uranium enrichment facility of Iran. So this is located in Iran. Second place I gave was Dimona. So Dimona is located in Israel and it is located in Negev Desert. So you have to look for the desert also. And third was the Keshem Island. So Keshem Island is located in Iran. Second important thing is it is located in the Strait of Hormuz. That's why it became more important. So I think yes, these were the news. I hope you looked for the location, you looked for the prelims related facts because in this manner, no, you will complete your geography, environment, and map related things. So please keep on looking things which we are discussing here. And for yes, this